In this video, we're diving into Section 5 of the California Residential Purchase Agreement, additional terms affecting purchase price. This section explains how the buyer's money is structured, from the initial deposit, loan terms, and balance of the purchase price, all the way to credits and cash offers. It's where we find out how the buyer is paying, who's lending, and what conditions apply if financing or credits are involved. Whether it's an all-cash deal, a conventional loan, or FHA/VA financing, Section 5 breaks down the details that make up the total purchase price and ensures that everyone, buyer, seller, and escrow, is on the same page. In this lesson, we'll go step by step through each part of Section 5, including how and when deposits must be delivered, what happens if a buyer fails to deliver the deposit, how loan types and financing terms are disclosed, the difference between cash and financed offers, and how lender limits can affect buyer credits. Understanding this section is critical for compliance, smooth escrows, and protecting your clients from financing pitfalls or invalid contract clauses. So let's jump in and break down Section 5, additional terms affecting purchase price, line by line. Section 5A1, Initial Deposit, how and where it's delivered. Buyer must send the earnest money directly to the escrow holder. The default method is wire transfer. If paragraph 3D1 says a different method, check, cashier's check, etc., but escrow won't accept it, escrow can require a wire after notifying the parties. Remember to calendar the due date in 3D1 and confirm escrow's wiring instructions verbally and by secure email. Section 5A2, Retention of Deposit, Non-Refundable, trap if paragraph 26, Liquidated Damages, is initialed or another clause is added. This is the seller's remedy if buyer defaults. RPA warns, don't slap in non-refundable language unless it independently satisfies California's liquidated damages law. Otherwise, that clause is invalid. It also warns, buyer can still face other liability if they fail to deliver the deposit at all. Remember, if you want deposit remedies, use the standard liquidated damages, initialing in paragraph 26. Avoid custom, non-refundable wording without legal counsel. Section 5B, All Cash Offer. If Section 3A is checked as all cash, no loan is needed to buy the property. Buyer must deliver written verification of funds for purchase price plus closing costs within the time in Section 3H1. Proof of funds should show buyer's name and liquid availability, redact account numbers. Section 5C1 First Loan. The default is conventional though first loan is assumed conventional unless FHA, VA, seller financing, car form SFA, or other is checked in Section 3E1. Section 5C2, Additional Financed Amount, Second Money Source. If Section 3E2 specifies an additional financed amount, that money is also assumed conventional unless seller financing, SFA, or other is checked in Section 3E2. For example, buyer does 80% first plus 10% second. If the second is a seller carry, check SFA in Section 3E2 and attach the form. Section 5C, 3 Buyer's Loan Status and Lender Contact Authorization. Buyer authorizes seller and seller's agent to contact the buyer's lenders to determine loan status for the loans in Section 3E or any alternate loan buyer pursues, whether or not the loan is a contingency. If lender contact info changes from what's in 6B, buyer must provide updated lender contact within 1 day of seller's request. Remember to get your buyer to sign lender info releases early. Respond quickly to 1-day requests. Section 5C for FHA/VA specifics. If FHA or VA is checked in Section 3E1, the FHA/VA mandatory clause, car form FEC, must be incorporated and signed by all parties. Buyer must, within the Section 3E1 timeframe, deliver written lender requirements, use car forms RR or AEA, and say whether the lender requires the seller to pay anything or if no lender requirements exist. It is important to note, even though buyer may obtain FHA/VA financing, seller is not obligated to pay lender requirements unless the seller agrees in writing. Remember, if the appraisal or lender conditions shift fees to seller, negotiate a written credit or price change, seller isn't automatically on the hook. Section 5D. Balance of purchase price, down payment. The rest of the price, including all cash funds, goes to escrow per escrow's instructions. This is the buyer's down payment plus any cash portion not covered by loans. Remember to confirm final funds to close with escrow 3 to 5 days before close of escrow. Arrange wired funds early. Section 5E. Limits on credits to buyer. Any credit to buyer from Section 3G1 or any later agreement must be disclosed to the lender if there's a loan. If the total agreed credit is more than the lender will allow, lender allowable credit 1. The contractual credit is reduced to the lender allowable credit. 2. No automatic price change happens to compensate for the reduction unless the parties agree separately in writing. For example, if you promised $15,000 in credits, but the lender caps it at $8,000, the buyer only gets $8,000 and the extra doesn't magically lower the price. Remember to ask the lender early for the max seller credit based on program, LTV, and fee structure. Set early expectations with your client.